So please respect all of our speakers. That includes ourselves as the volunteers and all of our organizers and the presenter tonight. So about Ari, he is a lawyer at bylaw. He is known in the legal community as the academic librarian, and he's been a mentor to a number of different family lawyers in the community. Our outlines today, we're going to identify what is and is not admissible evidence in court, understand what compelling important evidence is used in family court, and then how to draft and introduce affidavits into your hearing. Okay, I'm going to pass it over to Ari.
All right. Hi, I can't all see you, but I'm assuming you can all see me. So I'm going to be talking to you about affidavits. And, you know, it occurred to me, and I don't know if you guys got this thing in advance, but it did occur to me that I didn't really talk about what an affidavit is. And an affidavit is simply a document wherein you set out your story. And that's important to bear in mind as we go through the rest of this. You know, in terms of what it is that you're trying to convey in the document, and at the same time as you're trying to be somewhat restrained about it and fit, you know, within the rules, it's also important that you understand sort of how a story works. You know, you see a 2-hour movie, and it's about something, I don't know, but you don't see every detail of the characters' lives, right? You see the bits that the filmmaker thought were important and that the filmmaker thought conveyed the message or the questions they were trying to have you think about most effectively. And an affidavit is very much like that as well. You know, it doesn't matter what it is, you know, whether it's a 1-hour hearing, you've got a full day, 2 days, even at a 10-day trial. A judge is not going to know everything about you, and there is simply no way for you to convey everything from birth up to present, you know, the history of your life to the judge. So you have to make some selective calls about what is important and what is relevant to these issues. And that's kind of what drives a lot of what I'm going to talk to you about this evening. So to begin with, you folks are not litigators. You know, unlike me, you don't do this day in and day out for a living. You know, you guys are tourists in the country that I and other lawyers, certainly family law lawyers, live in. And like any good tourist, you know, you kind of want to know what the rules are of the country that you're visiting, so you don't end up locked up. And for better or for worse, although rarely, sometimes in the family context, it's not just a figure of speech. The foundations for anything that you do in the course of family law litigation is the Supreme Court family law rules. And Rule 10.4 sets out the requirements with respect to form for an affidavit. And you should always read the rules, particularly when you don't do this professionally for a living, to remind yourself and go back to basics. The nutshell is you, except for guardianship affidavits, which I think are covered under Rule 15.2, I want to say 15.2, 1.1 or 2.1, but I'm not going to go in there. You need to use Form F30, which you can download from the court's website. And again, please read the rules, but here are a few highlights. So one, the affidavit has to be written in the first person. So you use I, not Mr. Wormley, but I. If you are a party, you have to state this at the beginning of your affidavit. You have to say, I am the claimant or respondent by counterclaim in the herein action. Your paragraphs need to be numbered consecutively. you know, 1, 2, 3, 4, 5, 6, 7, etc. You need to have your name and the number of the affidavit at the top. So affidavit, this is the first affidavit of A. Wormley, will be there. The affidavit needs to be sworn by a lawyer or notary. You can also go to a courthouse and have the clerk swear it there. They'll charge you, I think, $40 for it, I'm told, plus maybe tax. I'm not sure if that's inclusive. But be aware that, you know, you'll have to make copies after you swear, and the courthouse will charge you $1 a page for any copies. You have to swear or affirm that the affidavit is true. The contents of the affidavit are your responsibility. It is your story. It is not mine. It is not some other lawyer's. It is not the clerk's. It's yours, and you are responsible for its contents. There are special inclusions available for people who don't speak English or who can't read. You know, so there are certificates of translation and whatnot that can be appended to the back of it. Exhibits, which are documents that you may attach to the affidavit, need to be marked. Technically, only exhibits of 10 pages or less need to be attached, but in practice, really, you should just attach all of it. If you choose not to, everybody else will be annoyed at you for it, and frankly, you will probably end up being annoyed at you too for it, because it will cause you far more hassle than it's worth. So also, I've excerpted from, I think that's probably Rule 10.4 sub 12. So an affidavit must state only what a person swearing or affirming the affidavit would be permitted to state in evidence at a trial. So that is things that are relevant and things that that person has what's called personal knowledge of, and they can personally say are true. That's things that they saw or heard. An affidavit can contain statements on what's called information and belief. If the source is given, the affidavit is made in respect of an order that does not seek a final order or a change in or suspension or termination of a final order. Also can't involve contempt proceedings. Basically, anything that's in what's called an interim application, you can use statements on information and belief in. And you signal that by saying, person X has told me, and I verily believe it to be true, that whatever it is that they've told you. And that can be used on an interim application. And that kind of statement is while not quite as strong as sworn evidence, can certainly be bolstered by attaching documentary evidence, like somebody told me this, and I swear it to be true. And I verily believe it to be true. And then you attach, you know, as an exhibit, you say, now produce to me, and attached to this my affidavit is Exhibit A, is a true copy of the email wherein, you know, they said it. And then at the court can at least, you know, take comfort in the fact that, yeah, this person probably at least made that statement. Whether the statement is true or not is another matter, but at least they probably said it. So in terms of what you can put in an affidavit, as I said, anything that you could say at trial, mostly things that you witnessed. I already talked about interim applications, and again, one thing that I would stress is just because you can put in information and belief doesn't necessarily mean that the court will, you know, take that as something that's true. Particularly if the other person offers sworn evidence to the effect that it is not true. The main point here, though, that I want to stress is that affidavits are for facts. They are not for argument. It's not a notice of application or an application response. It's not a factum. That stuff doesn't belong in here. Okay, so where you put two facts together and make an argument and say, therefore this is true or therefore that is not true, that doesn't go here. That goes in a different document, and it can certainly be conveyed orally to the court. It doesn't go in an affidavit. So, um, moving on. So things that don't go in an affidavit. Opinion. As a general rule, nobody cares what you think of the other person's parenting. No one cares what you think about their shoes. No one cares how crazy you think the other person is. Likewise, no one cares how shocked you were that somebody did such and such. The only person whose opinion matters in a family law case is that of a judge or master, the decider of fact, and they can make up their own minds. Um, I can't count how many times I have clients write, I was shocked when so and so did this. And I think, why does it matter that you were shocked? And most of the time it doesn't. And it's just somebody doing what essentially amounts to virtue signaling. Um, which is easy to do when you're talking about your own thoughts. And frankly, it's not very persuasive. Let your actions speak for you and let the facts speak for you. Argument. Again, this is not your place to score points. This is your place to set out the facts, which you will use to score those points. And irrelevant statements, especially ones that are engaging in muckraking. And another word for that is just mudslinging. No one cares if someone cheated on their taxes in a parenting application, and it's probably not relevant. And frankly, it risks stepping on the judge's patience if you've got a lot of that stuff in there and especially if you're going over it in argument, and the judge is sitting there thinking, why do I care about any of this? And boy, I don't know what to make of this in terms of the other person, but this sure shows poor judgment on your part. In terms of what you should put in an affidavit, so there is a concise and accurate answer. It depends. And the first question you need to ask yourself is, what is the point of this affidavit? Right? What am I trying to achieve here? It's just like what a filmmaker does when they're making a film. They try and think about, what is it that I want the audience to go away thinking about? What is it that I want the audience to feel? In your case, what are the essential facts that I want the judge to know about? And there are a few possible and typical goals of an affidavit. So that is to establish the background of the case as a whole, essentially dealing with everything. To achieve a more specific, limited goal, this is an application in respect of child support, or it's an application in respect of parenting time, or disclosure, etc., and to respond to an affidavit that somebody else has written. Those are the three most common goals. So let's talk about the first one, which is establishing the background of the case as a whole. So you'd use this near the beginning of the case, or you may be in support of a summary trial application, which is an application where you're running a trial, but you're doing it all by affidavit evidence. So the advantages to this is there's one document, and this has everything in it that you need, at least up until the date when it's sworn. And so you're not having to go back and go, oh yeah, this thing happened at some point in our relationship, and this other thing happened at some point in our relationship. You've got everything there, and you've got it done once, and you can keep reusing it, and you're never going to have to spend time on that again. So, talking about property division, spousal support, parenting, date of cohabitation, date of separation, any of those topics, it's already covered. And it may contain much information that is irrelevant to any given application, right? If you're doing a parenting application, you don't need to know about property division, for example. You do have to remember and bear in mind that affidavits are a little bit like a buffet, right? You have it, it's there if you need it. You do not need to go through the whole thing in every single application. And as a matter of fact, it's probably better if you don't. I draft an affidavit, or I assist in drafting an affidavit. And then once I've got the other side's response and I've got my client's reply, then I make decisions about, okay, what do I actually think the judge needs to know about? Certainly at first instance from here. And maybe I don't need to waste a whole bunch of time going over certain issues. So the other side, the other advantage is that the other side, you throw in a large omnibus affidavit, the other side may not respond to all of it, certainly the parts that aren't relevant. And then when you reuse it in future, they may have forgotten that they have not, in fact, responded to all of it. And so you get to throw in a bunch of stuff without the other side having actually contradicted you on any of it. So that has a possible advantage. In terms of cons, it can result in a large affidavit, which can be unwieldy. It takes a long time to write. You're also fixing yourself to one particular position and one particular way of looking at past events at a point in time where you may not fully comprehend the issues or what is or is not important about those past events because they're not front and center for you, and you may approach them unnecessarily casually. For example, did your friend Amitabh give you $5 to do something, or did he lend you $5 to do something? If you're not focused or detail oriented and you use the wrong word, gift versus lend, it may later get used as a club to hit you over the head with if you didn't describe it accurately. You may also, in the name of being efficient, omit or not talk about certain details. And if you don't do that, the other side might go, well, why didn't he say this before, right? Um, for example, I noted here, detail may suddenly become important. You note a number of incidences of your ex's misbehavior, but you fail to cite the time they keyed your car. You later bring up that they keyed your car, and then you get questioned about whether or not this is a recent fabrication. This is something you've just recently made up because you didn't have it in your long laundry list of complaints, right? So that's certainly something to bear in mind. In terms of it being large and unwieldy, this is going to have to go in a binder if you're going to use it, right? One, obviously, that's going to result in increased photocopy costs. Two, you're going to have to carry those binders around. Three, you're going to have to give that binder to the judge. And, particularly if you're going in for what you're telling the judge is a short 45-minute application, but you've got, a binder this thick, the judge may be looking at you thinking, well, how is this really going to happen within the time estimate? And if the other side wants to adjourn, that may provide some ammunition for them in that context. So next is to achieve a more specific and more limited goal, like you're just talking about interim spousal support or something. And this is the more common affidavit that you'll usually see, and focuses only on what somebody's asking for in a notice of application. So when do you use this? Well, whenever you don't use the omnibus giant affidavit approach, or when matters are pressing or urgent and you do not have the time. And yes, as I noted above earlier, it's rarely helpful in convincing a judge that your matter is urgent or can be dealt with quickly by handing them a 300-page affidavit. So the pros is it's more concise, more narrowly focused, It's easier to look through. It's something that if they want, and they don't usually, but if they want, a judge could look through on a lunch break, for example. Um, it means nobody is potentially responding to at least large portions of materials that aren't really relevant to the person deciding the application. You know, you put a large affidavit out into the wild, you're going to get potentially a large response back. That means your reply is also maybe going to be large. Um, so, and that's an issue because when you're serving on 8 business days notice, which is how most interim applications work, you're going to be having 2 business days at most in between the time you get the response affidavit and in between when you have to file it. That's not a lot of time. So again, that can be helpful. So the cons, it's easier to leave something out by accident because you're not thinking, oh, I have to include everything and perhaps going over it with the same detail. And two, you may end up having to talk about all the other stuff anyway at some point in the case. The third thing that you might use an affidavit for is to respond to an affidavit that somebody else has written. Um, you use this when it's not your application, and you're got to respond to it. And in terms of pros, well, yeah, if you don't want an order made against you, you probably need an affidavit. It would be the rare case where you could simply defend yourself using the other side's materials without needing to provide any facts of your own. I'm not saying never, but definitely rare. Um, the cons, none really, providing you do it well. Just remember, you can still take the 2 approaches above to this affidavit, right? You could do the everything in the kitchen sink approach, but you can also do something more narrow and focused on what the other person is talking about. Now, and again, typical application timeline, you've got 5 business days to produce this. So if your giant omnibus affidavit is not already in progress, now is probably not a great time to start it, I will say. So in terms of writing a responsive affidavit, I will say don't get caught up into the roadmap that the other side is laying out for you, right? Again, an affidavit is a story, right? And the other person is telling their story and their narrative. And if you get too sucked into their narrative, it may be hard for you to mentally sort of break out of that and go, hey, but there's these other things that they haven't raised that I need to talk about. So my suggestion is, after reading the other side's notice of application and having some generic idea about what the application is about, you start writing your own affidavit as if it was your application concerning this subject matter. And once you've done that, okay, once you finish that, then you go back and then you look at, okay, this is what they've written and this is what I need to respond to. And that's important too, because you absolutely do not want to miss responding to an allegation that the other side has made, right? It's important that you dot those I's, that you cross those T's, and that you have something to say about anything that they've said. Um, so, in terms of what goes in the affidavit, again, everything that you can swear to that is relevant. And yes, that's Dr. Obvious right there. So this is kind of where research comes in. So you should have some idea of what matters to the issues that you're dealing with, right? You've either sort of been looking at drafting a notice of application and you've done the research, Um, or you've received a notice of application and you're thinking about, well, what goes in my application response? And one of the first things you look at is research, right? What are the appropriate legal tests? What's the authority of the court to order this kind of relief? What are the tests for ordering this kind of relief? What factors do courts look at in the case law that you've researched, right? So that's having some sense of that is important. What have been some successful defenses in cases that you've read? Um, how does that fit into the fact pattern that is available to you? In other words, your life. Um, so for child support, right, people's incomes are what matters, and potentially only one person's income. Um, so while property and assets can sometimes matter, the fact that somebody forgot to give Timmy the proper reindeer last Thursday doesn't really have anything to do with it, right? It's not a relevant fact, and nobody's going to thank you for including that in the materials, and even less for actually bringing it up in argument. Um, so a good guide is the family law interview checklist. Um, I don't actually use this myself for interviews. Um, my interviews would probably last 3 hours if I did, but it does serve as a good go-to guide for what to include in an affidavit. You can see there's a link there. Um, it is a pretty comprehensive list, just to give you a few highlights. So, for financial details, it's got things like, amount and sources of income, jobs held and income earned throughout the relationship, periods of unemployment and reasons, any foreseeable change in job or income, future intentions regarding employment and retirement, if currently in school or training, what this will cost, and employment goals and probable earnings, right? So if you're not sure, geez, what should I put in? This is a great place to go. Skipping over a few categories, um, real property owned by either spouse since the beginning of the relationship, address and legal description, registered owner, when it was acquired, how much was paid for it, the source of the funds, mortgage amount, mortgage lender, any contributions by a third party. If acquired before the relationship began, market value and date the relationship began, whether an appraisal is available, mortgage owing when the relationship began, right? So it's got lots of good prompts. Uh, property, businesses, whether incorporated or unincorporated, name and address of the business and principals or participants. If incorporated, registered and registered records offices, directors, shareholders, type of business, number and ownership of shares, acquisition, date, price, value, if sold, when sold, selling price, net proceeds, if still owned, liabilities each spouse is responsible for, including co-signed loans and guarantees. Um, you know, uh, what else do we have? It covers debts. Um, whether the client or spouse, so you or the opposing party, is about to receive an inheritance. Who received it? How much? What was done with it? Any windfall, lottery winnings, prizes, gifts from family. Who received it? When? How much? What was done with it? You're sensing a pattern here. All of these things are important. And so if you're ever at a loss, go back to this list. Um, so what is or is not relevant might vary on a given application, but this list is a great place to start if you're stuck, right? It's not the end point, okay, but it may be a beginning point. Um, or if you think you have some idea about what you want to write, by all means, go ahead, write it, then look over the section and go, hey, have I forgotten to put anything in there? You know, It can be used to sort of double check your work. Um, so the good stuff starts at D114, Part 4, collect information. But I actually think that you should read the whole thing if you're a self-represented litigant, um, because it provides a lot of background information and context and things that you may want to think about, particularly at the beginning of a case. Um, so when I'm working with a client, I usually ask them a list of questions, and then I ask them to answer those questions in complete sentences, paragraph format, numbered. And so, for example, I have a super duper patented secret parenting list, and it goes something like this. And obviously, it varies depending upon the application, but this is kind of, the guts of it. So I ask the client for your name, age, and occupation, your ex's name, age, and occupation, when you began cohabiting, when you married, when you separated, names, birth dates, ages, and grades of children, history of employment immediately before and during relationship, work at present, and the hours, right? I mean, it's one thing to just say, oh, yeah, give me 50-50. Okay, fine. But could you actually make use of that? Do you have time? Is your work flexible? Can you pick the kids up from school? How's that going to happen? Right? Um, Anything you did in advance of your children being born? Did you read any books or take any classes, um, go to appointments or anything? What did you do to prepare yourself for the child's arrival? Participation in child care when the child was born, diapers, feeding, bed, bath time routine, who supervised tummy time, that kind of thing. Um, how did each of them nap? Who put them down for the naps? Was one child more alert or demanding than the other? I don't know. The things that you did when the children were growing up. So, taking them to their immunizations. Who looked after, if you've got two kids, who looked after child one when child two was born? Were the kids ever hospitalized when they were younger? And if so, what happened? Did you take off work? Um, who found doctors and dentists? Once the doctors and dentists were found, who took them to the doctor and dental appointments? Who arranged and took them to play dates? Who taught them to tie their shoelaces? Ride a bike, brush their teeth, read. When was the last time you took the kids to aquarium or science world or something like that? Who found daycares for kid one or kid two when they were younger? What was your involvement in finding a public school or private school, whatever, for the first kid or the second kid? Things they like to do as toddlers, right? Favorite books, songs, games. Things they like to do now. Favorite books, songs, games. Who were their best friends? Who attended parent-teacher conferences? Um, Favorite memories of each of the kids, and if it's different, and you've got one for each. If you've got two kids, then please, talk about one for each. One paragraph per child about what you think is most special for them. Did you ever care for the children overnight by yourself, especially if you're not a primary parent? When and how recently? Talk about the division of labor and caregiving immediately prior to the date of separation. Talk about the role of grandparents in the kids' lives. Talk about any allegations about your ability to parent and the day of the split. Those kinds of things. So I'm not going to belabor that further. Um, but again, those are some things that you can think of to to start things off. Um, and I always finish by asking the client anything else you think is relevant, because again, I don't know their life and the judge doesn't know their life. And there may be some things that I have not touched on because it just hasn't come up yet, right? Um, so, in terms of the specifics, actually, and we're at 6:09 here, so actually now I think is a good time to take that 10-minute break before I start talking about the specifics of the affidavit.
It's up to you, Ari. If you want to keep on going, we're okay. If you want to take a break, though, we can go ahead and do that.
Why don't we take a 5-minute break, maybe,
Perfect. Yeah,
and then come back?
sounds good. Okay, so everybody, we're gonna come back we're gonna take 5 minutes. So just grab some water, take a quick break. So we will come back at 6:15. So 6:15. We will see you guys then. Okay, welcome back, everybody. That was just our quick little break, so we're gonna get started again. Just gonna share my screen again. Oh, it restarted. Sorry, give me 1 second here. Okay, and we'll pass it back to Ari.
Okay, so in terms of advice that's maybe a little less generic, so the first part of every affidavit is the same. I, name of address, job occupation, swear or affirm that I am the claimant, respondent, yada, 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 right? That paragraph starts off the second one, I am the claimant respondent in the herein matter. Um, that's the first paragraph of every single affidavit ever. Um, and then the one above that is a little header. And you would use that except unless you're doing contempt, which is one of those things where no hearsay is permitted, is the kind of application that where you can only give the kind of evidence that you would give at trial. And then you would just say, I am the claimant or respondent in the herein matter, and has such a personal knowledge of the facts and matters hereinafter deposed to, because we do not use information and belief on contempt applications. Um, so then the other thing that tends to go in pretty much every affidavit, unless I know that I'm going to be using an older previous affidavit that already has this information, is the basic background. So and so and I began cohabiting on date X, were married on date Y, separated on date Z. Two children of the marriage or relationship, namely so and so, born on date whatever, who's currently 8. Um, uh, and I might note that parenting is shared, or the children are primarily resident with one person or the other, depending. It gives a bit of a background so that the judge can kind of orient themselves to whatever other issues are going on, you know. Um, uh, what else? So I always refer to the other person as Mr. or Miss X, right? So unless there's some other title that they're due. So they're not, Ashwarya or Abhishek, right? Um, if there is documentation available for anything that might be controversial, you can include it. You write, for example, um, the daycare provider, Miss Curmudgeon, informed me, and I verily believe it to be true. Right. So there's that information and belief. We've identified the source. We've said that we believe it to be true. And now we're about to say what that information is, that our daughter, Karen, was dropped off by Mr. Clean without her rare African snow leopard. Now produced to me and attached to this, my affidavit as exhibit blank is a true copy of the relevant email. So, as I said, this is an example of hearsay. It's information and belief. And, as per the rules, we've identified it. Um, and we've identified where it comes from. Uh, Karen may not have had the leopard when I picked her up, and I can swear to that, but it's hearsay for me to say that, oh, she didn't have it when when she was dropped off, because I didn't see it, right? That's hearsay. And presumptively inadmissible, except great news, is an interim application and we can use it. So now the daycare's email, right, that might be given more or less belief or more or less weight, as it's frequently called. But at the very least, it establishes that I'm not totally making this up. And why would the independent third party lie about it, right? The daycare provider probably doesn't have a stake in this race. Um, Having said that, I have had daycare providers fib about things. I don't know why. I don't even know if it was deliberate or they just weren't paying attention. But yeah, sometimes they do. But you know, generally they've got no reason to. There's a famous case called Subramanian, and I can't remember the rest of it, the case name, but it talks about hearsay, and so it's an important distinction. So, and when you can use hearsay and what you can use it for. So, somebody said that somebody else had threatened to kill them. And that statement was not admissible for the truth of its contents. So it was not admissible for the fact that the other person genuinely intended to kill them, right? And it's hearsay, and the person's belief in the fact that it was said doesn't make it true, but it was usable as narrative, which is one of my favorite exceptions to what's called the hearsay rule, the narrative exception. It was used for the fact that it was said to explain the narrative, to explain the person's subsequent actions or actions that took place after the statement, after having received the threat. For example, they threatened to kill me unless I went to the grocery store. Well, that explains why you went to the grocery store when maybe that might have been something unusual. Doesn't mean they were actually going to kill you, but it does serve to narratively explain why you did that. Again, though, the rules do allow hearsay, which is where somebody told me something, right, to be used on interim applications, but it does for sure go to weight. Hearsay usually loses against sworn testimony. If if you say, hey, here's the daycare provider telling me that it's true, that the snow leopard, that the Karen was dropped off without the snow leopard, and then the other person swears an affidavit and says Karen was dropped off with the snow leopard, that's not a great place to be in, which is why it would be better to have the daycare provider swear an affidavit. That's ultimately discretionary and up to the judge, but all other things being equal, sworn affidavit evidence prevails. Right. And again, it is discretionary where you do have it backed up by documentary evidence. You may luck out and the judge may go with what you said in your affidavit anyway. Double hearsay, which is somebody told me that somebody told them, is never admissible. Court is not telephone tag, and those statements are unreliable, and we don't include them. They're always going to be admissible. Hearsay from the other party, though, may be what is called an admission against interest. That's where they've said something that hurts them. And when somebody says something that hurts them, that's always admissible. And that's, again, one of those exceptions to the hearsay rule. For example, a text message, that's technically hearsay, but it's frequently an admission against interest when somebody says something silly, like, if somebody says, "Oh yeah, no, I'm not going to bring the kids over to meet with you until you pay my child support," for example, technically hearsay, right? You don't know it's true; it's just what the person said, but it's an admission against interest, and that person is going to be having to tap dance pretty hard to explain their way out of that text message. So I'm not going to go into all the exceptions to the hearsay rule. There are some created by the Evidence Act. Again, not going to go into them. Business records exemption is one of the more frequent ones, though. And most common example I see of that is probably bank statements. It's a record that's made in the ordinary course of business. Bank statements frequently go in. When attaching text messages, I will say, make sure you either preferably show the date or time of the text message, because sometimes I get these screenshots, and it's not apparent when the text messages are from. At the very least, though, if you can't provide a screenshot that has the date and time, at least put it in your affidavit and say, these were exchanged on March 20th, starting at 7:18 p.m., something like that. Generally speaking, it's best to attach an entire chain, whether it's email or text message, that deals with a particular subject matter to avoid accusations of cherry picking. Cherry picking just means being selected, you only show the good ones. This is especially important if you're putting it in a reply affidavit, right? So we've got the initial affidavit, the responsive affidavit, which is the other person's, and then the person who did the initial affidavit gets a reply affidavit. The other person does not get a chance to respond to that reply affidavit, and because of that, it is particularly important that you have the whole context, or the other person can just say, hey, look, it's obviously not the whole chain. You can't place any real reliance on that. And they can say, I have the whole chain, but I couldn't put it in because I don't get any more affidavits. Well, and then maybe you just torpedoed yourself, right? So sometimes, particularly if you think that the other person doesn't know that you have certain evidence, for example, they think you deleted all your text messages, or that, but you have got a backup, or maybe they made a recording and you don't know about it. Or sorry, you made a recording and the other person doesn't know about it. You can simply state a fact, right? Oh, this person said this. And then if they deny it, then you attach the text message, or then you produce the relevant recording. And sometimes that can be a useful way to attack somebody's credibility if they deny something, which it later turns out, yeah, they really should have explained that. Yes. Always never say never, and always. Never is almost always not true, is another thing that I say. And basically what this means is, don't have those words never and always in your affidavit. If someone says never and the other person attaches text message or photos of even one incident, then you've introduced a certain amount of unreliability in your statement. Almost never, rarely, occasionally, frequently, often, almost always, those are better substitutes. I recall an incident where somebody said that, my client had never helped with the child, after while they were in hospital after the child's birth. So my client went and attached a photograph of him holding the baby in what was very clearly the hospital. Oops, right? So for this reason, if no other, please try and keep communications between you and the other party in writing. So that means text or email, where the chain is clear and nobody can say, oh, so and so said this or so and so said that. And really, how do you know, right? How is a judge supposed to decide what was said or what wasn't said? And two, keep them civil. And this goes double if it's any kind of agreement about support, which you should never pay in cash, because good luck tracing it later when the other person registers with FMEP, or parenting time, including pickups and drop-offs. It avoids someone lying about whether there was an agreement, and it can also clear up what was potentially otherwise legitimate uncertainty about what the deal was. People have faulty memories. People don't hear everything. Text messages or emails are permanent. Get in the habit of not picking up the phone, right? If you guys are having to engage in litigation, make sure everything's clear. So these text messages or emails can also show how you relate to each other. You may think that the other person is a jerk, and that they're not acting in the best interest of the child. That's fine. As I said earlier, nobody's too interested in your opinion, right? Um, so you don't need to say in your text message or email, hey, you're being a jerk. If they're being a jerk and that's clear from the text messages or email, then guess what? A judge is going to be able to figure it out. And if a judge doesn't think that they're a jerk, they're going to be doubly unimpressed by you saying, hey, you're being a jerk, right? So let the other person's actions speak for themselves, right? You can write, and I put in as an example, I think Bruce will be really unhappy if they're forced to miss Selena's birthday, but I really wish you'd reconsider taking it. If you don't want to do it, I can do it. But don't write, you're such a so and so, you're a terrible parent, Bruce hates you, you're not acting in his best interests, and I still remember that time you cheated on me with Leslie. That's not going to look good, right? That's going to look like you do not have the ability to stay child focused. That's going to look like you can't help calling the other person derogatory names, um, and that you were part of the problem. It's going to make it very easy for a judge to say, a pox on both your houses. You're each as one as bad as the other, right? Um, and especially if you're in a fight about parenting, that's not a conclusion you want the judge to have. You always want to look better than the other parent. That happens, and that's true whether you're, fighting to maintain primary res or whether you're scrabbling to try and get some kind of 50-50 arrangement. Um, the judge might understand your behavior, particularly if they reach the conclusion that the other person is, in fact, being a jerk or such and such. But there's a difference between understanding and excusing. And in some circumstances, like if there are conduct orders or orders that say, hey, we have to communicate, the parties shall communicate respectfully to each other, what you're doing may even be a breach of the order. So don't do that because that can lead to an escalation in situations. So on that subject, text messaging is an instant form of communication, right? Somebody sends something, bam, and you get to bam, punch them back immediately, right? Feels good. Well, that good feeling could come back to haunt you. And what I would say is that waiting until the next day, rarely going to kill anyone. And if you're angry or worked up, walk away from the problem before you go and write something. Always assume that a judge will be looking at what you've written. Um, you know, uh, Sometimes what I tell clients, this doesn't work as well in text messages, but certainly in email messages, is write the email you want to write. Do not include the other person's name on the subject line. So no chance of you accidentally hitting send. Leave it. And then the next day, read over it again, think, hey, this is going to go in front of a judge and think, is this the me that I want to go in front of a judge? Is this what I want to show the judge about myself, right? Is this the story that I want to tell the court about who I am? And if you read that email and you think, you know what, maybe not, redraft it and then send it. And if you think, yep, no, this email was totally fine, hunky dory, then toss in the other person's name, hit send. Um, so that's one thing that you can do if you're using email. Yes. Oh, yes. So one of my all-time favorite clients, had this issue where, she was supposed to pick up the kid um, from her ex, and so she says, I'm here at the exchange spot. Where are you? And then he says, I'm going to be 10 minutes late, you bitch. And then her response is just, see you then. Perfectly child focused, didn't get on some parade about you're in breach of an order or don't call me a bitch or you're the bitch, even worse. Didn't get into it, just see you then. And in an era where it's more and more difficult for people to retain primary reds, she was able to retain it, and without having to really do anything incredible except for exercising truly amazing restraint and self control and staying child focused when the other person was very clearly unable to keep to that. So, let the other person rage and swear and call names and drag up irrelevant incidents from the past. Um, they do that enough and you keep your cool enough, it will come back to bite them, right? The court will see that. The 211 author will see that. Counselors will see that. And the other person is going to have a tough time digging their way out of it, or worse, the other person is going to try and explain why they think those statements were defensible. You know, that's not going to look good. Um, so be careful in an affidavit about getting too colorful with your descriptions. So don't talk about rages, talk about outbursts. Don't say, for example, in response to paragraph 10, that is an outrageous lie. You just say in response to paragraph 10, that is untrue, right? You don't need the adjectives. Um, don't talk again about how you were shocked by somebody's behavior unless, you actually went into a state of shock and you're using that to explain your subsequent behavior. Don't editorialize. Don't sensationalize. Sometimes what gets noticed in the crowd is not to try and outshout everybody else, but to be quieter and more restrained, because judges are used to, particularly from self-represented litigants, judges are used to everybody coming in and going, "Oh, this is outrageous," and this person is, they're not a nice person, and they keep sending the kid out in a raincoat on a hot sunny day, and they've got no business being a parent, yada yada yada. And did I mention they cheated on me with Leslie? Um, you know, they're used to that kind of thing. Um, so do yourself a favor and try and stand out from the crowd. Keep your affidavit child focused as well, right? And again, the judge can reach their own conclusions about what happened. Try and stick to the facts and the relevant facts. You know, if you want to make out that, hey, this person has a drug habit, okay, I mean, that's a fact. This person has a drug addict and is therefore an unfit parent. That is an argument. And that last part is what you would raise and say an argument. In your affidavit, you would just attach the proof showing that they are a drug addict and, they are currently a drug addict. One place where I do like to throw in a bit of color is where you're talking about parent-child bonds. You talk about quirks that your kid has, or your favorite memories of that kid, or what you feel like when you hear them singing in the car, right? Um, and on that subject, sometimes people like to attach photographs on the theory that a picture is worth 1,000 words. Mostly, it's not. A picture with somebody smiling doesn't mean they don't suffer from chronic depression. The fact that over a course of a year, 525,600 minutes, you have a picture or even 35 pictures where the kids appear to be happy doesn't mean they're always having a great time in your care. So doesn't mean it's worthless, and it can in fact be valuable. Oh yes, okay, yeah, I noted that bit about the hospital. You do have to think about the practicalities. It's going to make your affidavit larger. The judge won't read the affidavit. You'll have to take them to the pictures, which slows down your argument and sucks up time because time is always a premium in court, right? And does the picture translate well into black and white? Are you always going to have to make sure that you've got color copies? Um, you know, and so you have to be careful, and you also want to think that, when you think a picture is worth 1,000 words, right? You attach a picture, you know what context that picture was taken. You know what happened before and after. That picture for you is a gateway to memory. The judge, on the other hand, was not there before and after the picture was taken. For a judge, that picture is just that picture. They do not have that connection. On the other hand, you can use words and description in your affidavit to describe feelings and circumstances to the judge that may be way better than just attaching a photograph could do. So think about descriptions of those kinds of things. Right. Oh, yes. USB. So you may think, well, okay, all right, fine. You know what does show what happened before or after? Video or audio. And video or audio can be powerful. But one, it's difficult to employ on an interim basis on a chambers application because you have to kind of book machinery in advance. And every time you serve the affidavit, you'll have to attach the file. In other words, now we're not talking about, it may cause problems with any kind of email delivery, for example. And you can attach a USB, usually in a clear plastic hole punch sheet, the piece of paper in front of it with an exhibit stamp, but I really question whether it's worth it or not. Also, if you're going to attach video, everybody has their biases, right? And I've seen people absolutely convinced that a piece of video or audio is essential to their case, and I've watched them be destroyed by it in court when the judge takes a different view. In fact, in one case, AD and AP 2016 BCSC 2023, one party, AD, had made recordings. He played those recordings in court, and the justice found that the recordings he played showed his own testimony about what happened to be almost entirely false, right? So now I don't know what happened there, but clearly the judge took a different view of those recordings than AD did. So if you really think it's essential, maybe try it out on some disinterested objective parties and see, whether they hear or see it the same way that you do. And one of the best ways of getting that information, so you don't prime them with a whole bunch of facts beforehand, right? You just say, hey, what do you think of this? Or what do you take from this audio recording, and see what they say. So on that topic, surreptitious recordings. So those are recordings where the other person does not know that you've made a recording. And these days, that is easier than ever to do or to have happen to you. So a few cautions. One party consent is legal in Canada. If you are a part of the conversation, you are legally allowed to record it. But even if it is legal, courts don't like it. And third, even if courts don't like it, they will nevertheless admit it if it is reliable and where it is necessary to establish an important fact. So, you know, this can go for text messages. For example, somebody says, "Oh yeah, I've got an agreement, and apparently it's in writing." And I look at it, I don't see a clear agreement. Um, if you write, "I'm taking Donnie to the school," and the other person says, "Okay," that doesn't mean I'm okay with you taking Donnie to the school. That's just, okay, I hear or I see that you told me that you're taking Donnie to the school. Can I take Donnie to the school, followed by okay, is clearly an agreement. So you need to be careful about that, right? Because sometimes you're close to the facts and you think, oh, this is clearly an agreement. Somebody else may not reach the same conclusion. Um, one thing I will say about recordings is, in terms of reliability, you need the whole conversation, not just a part of it. The court needs to be able to hear the context. So, for example, if you start recording and somebody's yelling all kinds of nasty things against you or about you, well, okay, fine. But without knowing what you said to them beforehand, what's the court going to make of that, really? Um, so again, right, you need to be careful. Um, and in addition to the recording itself, it's usually a good idea to have a professional transcript done that you can attach to your affidavit. Um, Character references. Sometimes I have people who say, "Oh yeah, this guy will be a character references." Generally, not helpful. Um, no one cares if you're a good guy at work or a bad person at work. If they can talk about your bond with the child, right, because they've actually witnessed it, okay, fine. But this person is a good guy and they go to church every Sunday. Well, what does that go, right? Why is that relevant? Um, so likewise, bad behavior and conduct only goes so far, and I try and stay away from it, as much as possible. A lot of family law litigants hate each other with a fiery passion, and the fact that you also, like all those other family litigants, hate your ex with a fiery passion, well, that doesn't really help you stand out, as I said before. The other person's a monster, all right, fine. But if you've wasted your whole affidavit explaining that they're a monster without telling the court what makes you a good parent, well, you know, you haven't really done anything, because you need to convince the court why you are a good parent and why you are worthy of having some parenting time. And all that shows is you really don't like the other person and you're probably not going to be able to co-parent with them. So yeah, you need to be careful not to demonize the other party that I've talked about that before. Um, Section 37 of the FLA specifically sets out that the courts can only consider a person's conduct if it, quote, substantially affects one of the factors set out in that section, and only to the extent it affects that factor. So again, somebody cheats on their taxes, who cares? What factor under Section 37 does that go to? None of them. So don't bring it up. It looks like mudslinging, and it's more likely to lose you points in terms of making it look like you can't stay child focused. Um, Even where it might have some relationship to the child, you need to make sure that the concerns you raise are sufficiently on point. Um, and even better, uh, where you have solutions. Saying that somebody feeds their child day old rice is not likely to be viewed as a real reason for them not to have equal parenting time with the child. Um, and or you might raise issues where you say, hey, look, I think maybe supervised parenting time is necessary for the time being, but if they do X, Y, and Z, right, then at that point I'd be prepared to look at unsupervised parenting time, right? So you've got an actual goal in mind, or something, you know, concrete that somebody can do. For economic matters, it sometimes depends. So, for example, if you're looking at property division, you might write about exclusions, right? Property that you brought in. When did you acquire it? What was its value at the date of cohab? And where is the documentation showing it? How much is it worth now? Where's the documentation showing that? These questions, by the way, were in the checklist that I showed you guys earlier. If you made direct or indirect contributions to property, which could include companies, what was it and how? If you depleted any bank accounts post separation, you might need to explain how those expenditures were related to maintaining family property or debt, right? For incomes, you might talk about your income immediately prior to the relationship, their income immediately prior to the relationship, employment during the relationship, their employment during the relationship, how much you earned last year, how much they earned last year, whether each of you is reasonably employed, any health issues that either of you have, any unusual challenges or reasons why your income this year is going to be significantly different, etc. Section 7 expenses are an issue. You may want to talk about costs for the activity over the course of the year, requests you made to the other person, setting out the cost of the activity and requesting a contribution reasonably prior to the commencement of that activity. That is important for retroactive Section 7s. The history of a child's participation in activities during the relationship, etc. Like parenting, okay, everything is individual and it depends on your situation. These are some examples to kind of get you started. And I think they've sent out the PowerPoint slides to you, and you can use in concert with the interview checklist. So for responsive affidavits, I always have the following. I swear this affidavit in response to affidavit number blank of person X sworn on date Y. I generally deny all the allegations therein unless specifically admitted to by me. So this is a catch-up. It's there as a backup in case you missed something. If somebody accuses you of doing something really bad, don't just ignore it. Don't rely on this catch-all. Deal with it head on. If somebody says, hey, this person uh, took all the money out of our joint bank account and put it all into an account solely in their name that's, in the Cayman Islands, don't rely on the general denial. You specifically deny it, right? And say, no, I did not do that in response to paragraph blank. This is untrue, right? And then you say what it is that actually happened. So yeah, you say if it isn't true, or maybe it is true, but it's misleading. Like, yeah, I did that, but that's because I had taxes. We pay taxes in the Cayman Islands, and those were due. And I needed to send this money over to the Cayman Islands to pay those taxes, and here's the documentation, right? Or while I did not actually leave Whiskers, our African snow leopard, at the daycare, he was in fact there at the daycare when I dropped Karen off, but I did not leave him as I had to rush him to a vet appointment, right? You explain the issue, you set out that it's misleading, which means that, yeah, technically what they've said is true, but there are important facts that need to be borne in mind, and it's not really what it doesn't really flow with the narrative that the other person has set out. And this is important because you don't want to come off as being misleading yourself. So you make full disclosure of your side of the events. And a judge might view your behavior as right. They might view it as wrong, and may think you've got a distorted perception, but they won't think that you're hiding things or are otherwise untrustworthy. As a general rule, when responding to an affidavit, you want to respond to everything, at least and certainly everything that you don't agree with. Even if there are things that aren't relevant, I would still respond to them because you may not fully understand at this juncture in time why it's relevant. But if it later turns out that in fact it is, you'll have wanted to respond to that and to have admissible evidence dealing with whatever point that is. It's nothing that you would plan to bring up, but it's there. Remember, that an affidavit is like a buffet, and you can pick and choose, right, what you're going to use from it. Having said that, um, and especially in early affidavits, even when you're responding, it's best to take the approach that I indicated earlier and set out what your story is first, right? So the first portion of the affidavit, even a responsive affidavit, is your story. And then you start going in response to paragraph blank. This is untrue or this is misleading, right? Um, so uh, Also, bear in mind that the other side is entitled to a reply. However, that reply is limited only to issues that you raise in your responsive affidavit. So if somebody says something helpful to you in their initial affidavit, you may not want to respond to it, because if you don't respond to it, the other party doesn't get a second chance to put in more detail or fix it up, right? Um, So bear in mind that as I indicated earlier, for any application, there is one affidavit in support, one response affidavit, and one reply affidavit. That's it. Now, sometimes there are exceptions. Um, if you start a hearing and don't finish it, and in between, when the first hearing was and when the continuation is, new facts actually come to light or occur, then yeah, you could throw in an affidavit to say, hey, here's what happened since the last hearing. Absolutely. Um, However, generally speaking, you know, those three are it. And remember, if you do draft a new affidavit, I would deliver it 8 business days in advance to give the other side time to respond. Um, so the rules for a reply affidavit are similar to a response affidavit because you've already had your kick at the can in the first round. This is only response to what the other person has raised in their response affidavit. So unlike the response affidavit, you do not set out your version of events. You've already done that in your affidavit number one. This is pure reply. If all you're going to say is a repeat of your initial affidavit in support, then you don't need to say anything. As a consequence, a reply affidavit is generally going to be relatively short. Um, and you might have some ideas for things that might get said in a reply affidavit even before you finish your first affidavit. You might think, yeah, okay, I'm going to say this, and they're going to say this, and so then I'm going to say that back, right? So bear in mind a couple of things. One, if the other person does not file a response or doesn't respond to a given topic, you can't put in any more information. Okay, so if they don't say, oh yeah, but X, you don't get to expand anymore on that topic. If it is central to your application and to the success of your application, and you're only bringing it up for the first time in a reply affidavit, then this is what's usually called case splitting, and it's not permitted. Case splitting is kind of moving the goalpost. So you raise an issue or something in your first affidavit, the other party responds to that, and now you bring up additional issues or fix a gap in your evidence. And the other person doesn't get a chance to respond. And so that creates a kind of unfairness. And judges are loath to allow that, right? Um, So, and you're also going to include in this affidavit the same para that you would in a responsive affidavit. I swear this in response to affidavit Yank of name X on date Y, generally deny all the allegations herein, yada, 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 right? So, other people's affidavits. So, there may be times when it is beneficial, either initially or in response, or possibly even reply, though again, you need to be careful, to get affidavits from third parties, people who are not you or your ex. Just like you, they have to set out their name, their address, and occupation. Beginning of their affidavit should be, I'm this, sister, father, friend, employer of the claimant or respondent, and as such, yada, 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 that whole thing. They should always be aware that there is a potential to cross-examine on affidavits. I'm not going to go over what that means in great detail here, but they should be prepared for that, though it rarely happens. It basically means somebody gets an order and allows them to sit down in a room with a court reporter and ask the person questions about their affidavit under oath. I do want to note, you can't be sued for something you write in an affidavit. No one should ever be afraid to put the truth into an affidavit or worry that they might get sued for defamation or libel. Obviously, you still have a duty to be truthful, and there are consequences for perjury or lying under oath, but nobody can sue you for defamation on the basis of something you wrote in an affidavit used in a court proceeding. Sometimes, if you're not able to get an affidavit from somebody, you might be able to get an email. For example, a school teacher, they're not going to swear an affidavit, certainly not a public school teacher, but they might send you an email, which you can attach in your affidavit. And it's not quite as good, but it's almost as good. So the last part of your affidavit will have something called a jurat. And that looks, yeah, something like that. And that's where you swear or affirm it. If you're Jesse Pinkman, you sign on the right hand side after the oath is administered by, in this case, James McGill, who will then sign indicating that they've administered that oath. And James McGill will have to be a lawyer, a notary, or a clerk in a court registry. I will note, I wrote that the court registry won't charge you. The provincial court registry will not charge you. The Supreme Court registry, as I indicated, will charge you $40. If you're in a foreign country, you may be able to use a lawyer or notary there, assuming they can take oaths and they speak and read English, or alternatively, Canadian consular services. The jurat needs to be intact on the same page as your last paragraph, even if that leaves a weird gap on the second last page of your affidavit. Exhibits need stamps on them. Exhibit pages are supposed to be consecutively numbered, upper right-hand corner, ideally starting from the last page of the affidavit. So the last page of your affidavit is page 7. The first exhibit is on page 8. If you cannot stamp the exhibit without stamping it over, an important part of the exhibit, then I would use a cover page, a blank cover page. Exhibits are lettered as indicated above. So you got A, and then, after you hit Z, you do AA, BB, and so on if you've got a lot. And I have an example of what an exhibit stamp looks like. And that has to be signed by whoever is doing the affidavit. All right. So I think I've gotten through everything. So time for questions. Bring it on. Oh yeah, right. I lost the last page of my spiel. Right. Yeah. So remember, you need at least 3 copies of your affidavit. The original stays with the registry when you go to file it. You keep 1 copy at least. The other copy may need to be served on the opposing side. Even if you're doing service via email, which is now the case for most affidavits since September 1st, you will need to send them electronic copies of any audio or video. You'll probably need to get USBs to them, bearing in mind that you have a 4 p.m. deadline to serve. This is why it isn't usually a great idea to have USBs or anything like that. You can use Dropbox or something, which may or may not constitute good service, or you can attach it. But but then if you're attaching audio, you need to make sure that it's small enough and isn't going to break their inbox. Plus, the other side has a right to request physical copies in certain circumstances, etc. I've already talked about the registry. Lawyers, if one is assisting you, can sometimes file the affidavit electronically, depending upon the size. In certain circumstances, if there are health issues, it may be possible to swear the affidavit remotely with the lawyer. Now I'm ready for your questions.
Okay, so we have one question. It was in the beginning. The list of questions, I think that was the one that you were mentioning from the Law Society. For younger children, how relevant for children who are now young adults?
Right. I mean, and what I gave were examples, and everything is going to depend on on your individual circumstances. Having said that, it may still be relevant. I mean, young adults, if you're talking an adolescent, maybe it's less relevant, but maybe there's a dispute about who was the primary caregiver. Maybe, though that's probably not relevant because honestly, for the most part, once kids hit 13, there's more of an emphasis on what their views are. It's not to say that all the other stuff is completely, useless by any stretch. And I would certainly continue to include more updated takes on what what you do with the kids, fun things that you do with the kids. You may not be taking them to the aquarium anymore, but you might go rollerblading or rock climbing with them, maybe. I don't know. So again, yeah, adapt. But you can still talk about last Christmas, or maybe you guys have a hobby in common. Maybe you guys go running together. I don't know, right? So again, adapt. Um, and you may want to think about your own, but using that list of questions, I hope might at least prompt or put some ideas in your head. Anything else?
I'm sorry, you did. So there's a question about, am I correct in saying that an affidavit is like evidence in written form?
Yes, absolutely. That's exactly what it is. And in Supreme Court, an affidavit is the default way of getting evidence in on an interim application, right? In provincial court, what's called viva voce or oral evidence is still the default, but in Supreme Court, you don't see that except at trial. So yes, this is, for most intents and purposes, really the only way to get your evidence in on an interim application. And so properly drafted affidavits are critical, because if you just start saying stuff in court, well, who cares, right? It's not a sworn affidavit. You may get a little leeway on that as a self rep, but yeah. Anything else?
Yeah. Next one is, does a new affidavit need to be done for a trial if one was done at an interim order?
Okay. So trials work differently. Now, there are two kinds of trials in Supreme Court. One, which I briefly mentioned earlier, is called summary trials. A summary trial is a trial by affidavit. And if you have affidavits earlier, you probably don't need to redo them, bearing in mind that because it's a trial, all that good hearsay stuff that you had, so and so informs me and I verily believe it to be true, that's out the window, and that is of no assistance to you. On a regular trial, however, oral evidence is the default. You will not be using affidavits at a Supreme Court trial. unless it's a summary trial, you will be using oral evidence. The only things that you will be using an affidavit for is if you are using the other person's affidavits to cross-examine, where you say, hey, you said this in your testimony, but in your affidavit sworn blah, 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 paragraph blank, you said why, right? Or if you want to raise something that they didn't talk about in what's called their direct evidence, but they mentioned it in your affidavit, you can use it for that. But you will not get in evidence by way of affidavit for a Supreme Court trial. If you are doing an arbitration, which is something that you have to agree to, you might agree that somebody's initial evidence can go in by way of affidavit, but that's a process that's outside of the Supreme Court. Anything else?
Okay, we have 3 more questions so far. Can an affidavit be signed in a different province if a case is being heard in BC?
Absolutely. If you have a lawyer, I'm not sure if a notary in Quebec counts, but in most common law provinces, a lawyer or notary can sign it. In Quebec, I know a lawyer can. There's something in my mind that's telling me maybe not a notary. I can't remember exactly, but yes, absolutely.
Next one here is, can an affidavit be used to explain the date of separation?
Absolutely. On an interim application, absolutely. Or summary trial, yes.
Okay, there's a question from Kat. It has some personal details in it, so I'm not going to read everything here. But they obtained specialist reports regarding one of their children, and they want to know how they can approach that in an affidavit.
So what you would do is you would say, now produce to me and attach to this my affidavit as exhibit X is a true copy of, a report done by, Dr. So-and-so. And then it's there. Now, there may be questions about what weight do we give to that report on an interim basis when Dr. So-and-so has not been cross-examined. But that's how you get it in. And depending upon the nature of the report, the other person may have a hard time arguing that the court should disregard it. Certainly, and at the very least, it would be evidence that there is a live issue about whether the child has a learning disability or whether a child broke their foot. And so if you were using that report to say, hey, we need further disclosure about this or something like that, or the Section 211 author needs to be specifically directed to focus their attention on this issue, that would absolutely be good for that. And frankly, as a matter of practicality, if you're attaching X-rays showing a broken foot, you've probably got a good chance of making out, at least for interim purposes, of convincing a judge that yes, indeed, there is a broken foot. Or again, for interim purposes, if you're having an interim fight about, whether tutoring is appropriate because this child's been evaluated by an educational psychologist and the educational psychologist report recommends tutoring, you're sitting in a pretty good in a pretty good place to have that happen on an interim basis. I hope that answers the question.
Sounded like it to me. Does anybody else have any other questions? There's nothing else in the chat right now, but we do have a few minutes left, about 15 minutes if anybody wants to ask any more questions. We'll give it a minute to see if anything comes in.
Do your worst.
While we're waiting, at least, I just want to mention to the students here, we've made some changes to the syllabus. Potentially, we're going to be changing week 11, maybe doing an extension into a week 12. But we're going to be sending out a survey to everybody after this session in the next coming days. And so you can give us some feedback on that, and we'll give announcements about what's coming up. I don't see any other questions that's coming in. So yeah, we'll call it a night.
Thank you very much. I hope I haven't bored you too much. That is a lot of information to go over and to sort of vomit up at once. And so, yeah, I mean, don't hesitate to go back over your slides, and also remember that there are, and I'm sure this program is introducing you to some of those, but there are services available to people who need some assistance. You know, there's duty counsel available at the various courthouses. UBC has an LSLAP program. Depending upon your circumstances, there's also access pro bono, and of course, you know, legal aid and whatnot. But those are all services that are available to you. And sometimes, depending upon, you know, what you're doing, some law firms, I mean, Law certainly has this, and I know others do too, have what's called unbundled services, where you essentially pay for assistance with a given application. I don't, and for various reasons, I don't go into court on materials that other people have drafted, but I do help people who are going into court draft materials, and many of my colleagues do. And also, sometimes if you really have some focused questions, a number of law firms will also offer, you know, brief consultations where you can pick somebody's brain about a particular issue. And especially if it's an important issue, it may be worth paying somebody for an hour of their time. You know, if you, for whatever reason, aren't getting what you need from duty counsel or access pro bono or LSLAP or something like that. Also, I just realized, because of course we are on Zoom, so people may be appearing from around the province. The Law Center program in Victoria is also excellent, and specializes in people who make too much money to qualify for legal aid, but not so much that they can actually afford to hire a lawyer. And I'm sure there are programs that are not dissimilar throughout the province if you're in reasonable proximity to a university. Anyway, that's my bit. So good luck, folks.
Thank you so much for joining us, Ari. Thank you. Okay, have a good night, everybody. We're going to end the session tonight. Thank you so much.